With that, I will call 126442, State of Kansas versus Caleb Paul Ron Hogan. As council take the bench or their seats, I will tell you that like the students, the court has read the briefs and studied the record and have made notes about the cases. So we may be referring to those notes on our computers or on paper as we go through the argument. Please know that as we do that, it is part of our process of helping us assess the arguments of the council, and we are actively listening to them as they do so. So with that, Ms. Davis, you may approach the lectern.
I'm Michelle Davis, and I'm appearing on behalf of Caleb Hogan, and I'm requesting 3 minutes for rebuttal, please.
3 minutes is granted.
The state convicted Mr. Hogan of child abuse and felony murder based on events that took place in March of 2021, I believe. Mr. Hogan called the police, 3-month-old baby. It's afternoon. Child had slept most of the day. He found the child having trouble spitting up a little bit, vomiting, trouble breathing. And then the child went limp, and he called 911, and the child was taken to the hospital, did not recover. The police interviewed the parents that night, the father and the mother, and each of them denied that they had harmed the child or that the other would do so. There was also some family of the parents that had contact with the child, and then the child was with a caregiver every Thursday and Friday of every week. Other than that, the parents pretty much shared or divided caregiving responsibilities. The next day, the police called the parents back in, only talked to Caleb, and he was obviously not well, tired, distraught. He gave some statements during that interview that the police then arrested him for and claimed that he had confessed to the crimes. And they relayed that information to the pediatrician, the child abuse pediatrician that testified for the state at the hospital. So she prepared a report that said that law enforcement said that father had admitted to shaking the child, and that those kind of injuries could cause the rib fractures that had been identified at the hospital. There were some healing rib fractures on the child. And what Caleb had demonstrated was, a gentle shaking where he was holding the child in front of him. And it was that this had been done 6 weeks prior, where he was frustrated and was telling the child, go to sleep, I'm tired, kind of holding the child in front of him. And then after this event happened, where he couldn't get the child to respond, he had done the same thing, holding the child, trying to get the child to wake up. So
let me interrupt, because this is what's bothered me when I was looking at this last week. Is your contention that the prosecution misrepresented to the jury what the video showed? Your argument, you seem to be talking about, well, it wasn't the shaking that he demonstrated wasn't much.
right, because the video is there, we could observe it, right? And that was, well, I watched the video, so
Right,
then
but
also,
is it your contention that the state misrepresented what was on the video?
I'm going to give you a long answer if that's okay. Basically, this started with there's a captain with the police department who basically said, he confessed, he admitted to doing this. And so it's when you say the prosecution.
Well, I thought I said the state.
Okay, if you say the state.
Maybe the second time I said it, I said the state. I just,
Yes, and law enforcement, this started with law enforcement, and they decided he had done it. In fact, you could tell when they interviewed the mom that this captain believed that the dad had done it, because he kept trying to get the mom to say the dad had done it and didn't really confront her about whether she had done it. I mean, that's my opinion, but I watched the videos. So
I'm trying to figure out what to do with this, because in the end, the video is played to the jury and they get to see it, and they convicted. I don't know how I guess I'm trying to figure out what's the legal support for us to look at the video and say, oh, it's not as bad as the state represent. See what I'm asking?
Yeah, but that's not the issue here.
Okay, that's what I'm
Okay,
getting
so
at.
this case goes to a preliminary hearing in December, and that preliminary hearing. So the law enforcement comes out of the interview and they say he confessed, right? They put that in their affidavit that he had admitted to shaking the child, but they didn't explain what type of shaking he described, right? But at the preliminary hearing, Captain Ralph testifies. This was a gentle shaking. Those were his words. So Captain Ralph at the preliminary says he admitted twice to being a gentle shaking. But then Weeks, the child abuse pediatrician, also testifies at the preliminary hearing. She says this was a violent, forceful shaking to cause these injuries. So right there in front of the prosecution and the judge is the contrast. Then the autopsy, the state's autopsy expert says this was a blunt force injury. This was not even a shaking. Shaking could have been involved, but this child was struck on an object, or an object was struck on the child. So the evidence is there. Then the motion hearing comes up 4 weeks later, or 4 months later, 3 to 4 months later, where the defense is trying to prevent, what they're trying to prevent, it's not the videotape. They're trying to prevent the evidence of prior injuries to the child from being admitted because it's so prejudicial. Because the state had no proof that Kaleb had caused these injuries. And so simply putting in older injuries to this child without unknown perpetrator had no probative value of material fact in dispute and was highly prejudicial. The judge at that hearing says the state's going to present evidence showing a causation between the defendant and the injuries. This is a proffer hearing. It's not an evidentiary hearing. The prosecutor doesn't get up and say, that's wrong, judge. Actually, we don't have that evidence, so we can't do that. You heard the preliminary hearing 4 months ago, right?
Was there circumstantial evidence, though, to support that sort of theory in the fact that there was sort of this timeline established where for the prior injuries, some of the interview from the defendant where there was an acknowledgement of prior, albeit gentle, shaking, and therefore it's sort of a why isn't this just a credibility issue? I guess 2 questions. Why wasn't that enough for the jury, if it so chose, to make that inference that as to the identity of the prior who caused the prior injuries? And second, was it also based on that same evidence simply a credibility issue, whether the jury was going to believe Mr. Hogan or not, that made that evidence potentially relevant?
At the start of this second video, he's going in there going, you're telling me I did this. I must have done this. I can't think how this could have taken place. Maybe this gentle shaking I did it. He didn't use the word gentle, but he's trying to explain. He's trying to work with them. Then when the captain says, no, what you're describing to me couldn't cause these injuries. You must have done something more. And at the end of the video, he's going, no, I didn't do anything more. There's no credibility here. Take his statements for what they are. He denies seriously harming the child. And with the defense here, they don't have a problem. If you want to say, if he was inconsistent about the first interview, he said he didn't shake the child. In the second interview, he said he did. On the day in question, that's fine. You can bring in everything that happened around the events of what took place, right? And he denies that he did this. He denies that he previously harmed the child. If you watch that interview,
can you connect the dots for me between your argument about the interview and the judge's evidentiary ruling that's actually in front of us?
That's actually,
I mean, I take it what we're talking about here is the issue of the court's denial of defense's motion to exclude evidence of prior injury, right?
right, because
So I'm asking you
The
you're
judge-
spending most of your time talking about the interview.
Right.
I just want you to connect the dots for me.
right, because there's no evidence. There's no, you've got healing rib fractures, perpetrator unknown, right? The defense is saying, we're not disputing this child was injured. That's not a material fact in dispute, right?
So what is
So-
the legal argument as to why the evidence should be excluded?
Because 6455.
Okay.
because they're using this evidence. This wasn't just the evidence that came in. It was the detective saying, it was Captain Ralph saying, he did it.
Yeah,
He did it. It was the judge's limiting instruction saying he did it, right? So it's not just evidence of the prior injuries, it's they're pointing the finger at Kaleb saying he did this, right? That's 6455 evidence.
right, you're saying it was brought in for propensity, not for the purported reason that the court gave.
Right, because those things weren't in dispute. The defense wasn't disputing the child was injured, right? Let's see, the judge's reasons were that he didn't say, I dropped the child and that's how the child was injured, right? He's not claiming accident. He's saying, I didn't do this, right? So his state of mind and whether it was an accident, the reasons given are just not in dispute.
I thought the judge's ruling was that it went to the credibility about whether or not the shakings were gentle or at not, as he demonstrated,
Uh-huh.
and also as to the credibility that the last shaking occurred after the baby had been non-responsive and as opposed to having occurred before.
Mhm.
So why is that not
So what
go to
you-
the credibility of
Right.
those,
What you're
that
calling
timeline?
What you're
based-
calling credibility is really just saying, is he minimizing? It's just Captain Ralph's theory. I mean, all this is just Captain Ralph's theory just getting pushed down the road.
But
It's-
why
he's
doesn't the
minimizing.
jury-
The theory is he's minimizing, right? He's saying he gently shook the child, but he's minimizing. And so when the judge is calling credibility, is really saying, are you going to believe the state that's saying he's minimizing or not? And so it's really propensity evidence because it's saying he's not minimizing because look at the damage that was previously done to this child.
Well, we have case law that says with propensity evidence under 6455, even though credibility is not listed in that statute, credibility can be a factor that allows prior acts to come in.
Yes.
So why, that's why I'm trying to
Okay,
get to,
I'm going to give
why not here?
2 reasons here, right? This is evidence he committed a crime, right? That's not evidence. The state had no evidence that he committed the prior injuries.
he,
All we have is evidence of a gentle shaking and then denying that he caused the prior injuries. No, I didn't do anything that would have caused these significant injuries. At the time, he doesn't even know the extent of the injuries, right? This is the night, the day after it happened. He doesn't have all the autopsy photos and all that. He's just saying, you're telling me my child's hurt badly and I didn't do this, right?
didn't the, I'm sorry, I can't recall which doctor, either the pathologist or the Dr. Wells, say that holding the baby as described
Mhm.
could result in fractured ribs?
As what law enforcement had relayed. Law enforcement says dad admits to shaking the child and holding the child and shaking the child, right? But they didn't say the gentle shaking part, that this was very just kind of waving the child in front of me, right? So she's making her conclusion based on what Captain Ralph is saying and telling, right? As did, it just kind of filtered through the case. He did not admit, and at trial, all the experts acknowledged that. With the type of shaking that he described would not have caused injuries to this child. She acknowledged that, right? She never saw the video. She didn't know. She was just going off of what she was told. And they're proclaiming a confession here. So she's assuming this is the violent, forceful type of shaking that she said would be necessary at the preliminary hearing. And then the other part about why it's not admissible, you said this in Prine. The state can't open the door to 6455 evidence. The state can't, the defense has to open the door by its defense at trial or something that's said at trial. The state can't, the state admitted the video, the prior statements. The state can't do that and then say, we're putting in his statements. And so now his credibility is an issue. So we get to bring in 6455 evidence. I mean, if you did that in every case where the state was putting on the defense prior statements, they could always say credibility is an issue. Right? We've got something different at trial than what he said before, so we can bring in 6455 evidence. No, the defense has to open the door to 6455
wondering-
evidence.
If, as I described earlier, I was having trouble connecting the dots between
Uh-huh.
the interview and the actual evidence. And I'm
Mhm.
wondering if the disconnect is this even 6455 evidence? I mean, is it a prior bad act? It's just evidence of a prior injury.
Right, but the problem is you've got the captain telling everybody he's confessed.
Well, but that evidence gets tested in the adversarial process of the trial. And as you pointed out, the defense apparently was able to pretty firmly refute that.
No, I don't think so because he was convicted.
Well, I don't think you can reason backwards from that. The jury obviously didn't believe your client.
Well.
But my question
Or
really,
they were prejudiced by all of the evidence of prior injuries to the baby. I mean,
well, but the question is whether or not that evidence is admissible, right?
you can't have it both ways. You can't say this is not evidence of a prior crime when the state is saying it is evidence of a prior crime and telling the jury it's evidence of a prior crime through their witnesses and through a jury instruction. When everybody's telling the jury it's that, you can't say it's not that. If it's not that, then you admit the evidence of the injuries, you give a limiting instruction saying evidence of injuries to this child has been admitted. There's no evidence that the defendant caused these injuries. But then the jury's saying, well, why are you admitting the evidence then? How is it relevant? And you know what? If I'm on the jury and I've got a judge telling me to consider this evidence for accident, lack of mistake, credibility, I'm thinking this guy did those prior injuries because why else would the judge be telling us to consider it? And you know what? They're right. There's supposed to be a court finding before you admit that evidence. A judge has to find that it's relevant. In order to be relevant, he had to have committed those injuries.
He tells them you can't consider the older injuries to support the conviction of either child abuse or felony murder charge, but you may consider. So he distinguishes that. Is it as strong as what you're suggesting in terms of a directive to the jury?
You have the limiting instruction, but you may consider it for. That's a mistake. Is it, that's what you're referring to? Right. So what's he telling the jury to consider it for then?
So what's the,
He's telling him to consider it for whether Kaleb acted knowingly and if he was credible. I mean, so basically what the judge is saying is, you know, there's been some, what I'm thinking is there's been some finding here that where the judge found that Kaleb had committed the prior injuries, because why else would the judge be telling us to consider it? I mean, you know, if we're to consider prior injuries in determining whether Kaleb acted knowingly, he must have done the prior injuries, right? I mean,
my point is he's not really telling them to consider it. He's telling them they may consider it. Is there a
Right.
difference there?
but why would you be telling us that unless you're saying it's probative? I mean, it's probative. I mean, what else? It's probative of to say whether he's done knowingly. That's not his defense. I mean, he's not saying I did this, but it was, you know, an accident. He's saying I didn't do this, right? So this limiting instruction is just worthless because the jury either decides he did it or he didn't. There's no innocence here. There's no innocence defense. I think I'm out of time. I'll save my remaining comments for rebuttal.
All right,
Thank
thank
you.
you, Ms. Davis.
Morning, may it please the court. Darren Devaney on behalf of the state of Kansas. There's, I guess, the legal issues of 455 or the admissibility of this evidence, and then there were the facts of the case. I was anticipating, I guess, the analysis of one thing that's already been touched on, which was this evidence actually 6455? Because it's kind of, in a way, it's a little bit of a split order that we had in the pretrial motion in limine. And I want to make sure that this time frame is very clear with the court. There was a preliminary hearing that occurred back in December of 21. Some months later, the trial counsel for defense filed a motion in limine with the court. Putting this issue at hand, the state didn't file a 6455 motion. The state hadn't considered whether or not a 6455 needed to be filed at the time. It was trial counsel for defense that initiated this and kind of opened the, I'll say, not necessarily opened the door, but opened the argument up in front of the trial court.
What was your theory on the prior crimes if it wasn't 6455? I think I follow you, but what was it like?
Well,
Race gesti? What are we talking?
I was looking, my attention was focused on the autopsy itself. And let's get away from the defendant's statements for just a moment if we could. But the autopsy, We had an autopsy performed. It showed healing rib fractures on an infant child. Those healing fractures and blood on the brain, some of these types of things from the pathologist occurred 4 to 6 weeks prior to. And to ask a trial judge to excise portions of a autopsy because it showed prior injury, and we don't want to taint the field with any prior injuries. To me, that's a very untenable situation for any district court judge to go through and piecemeal what is scientifically valid for the purposes of proving this particular crime, as opposed to other scientific aspects that might be part of the autopsy that may not comport or may make somebody look bad, or would even be constituted or argued by a lawyer to be a prior crime or bad act. That is to say, that autopsy is its own document, which is objective in nature. It's presented to be objective, and that's going to include every injury or every disease, height, weight, everything. And so that was part of the motion in limine, but filed by the trial court defense, which was to excise those portions, excise the prior injuries to the child, because we couldn't bring that in. And he puts that in line with, in parity with, the defendant's statements, which he says, there was soft shaking. There was even mention in the interview that occurred in Newton with Captain Ralph, that I believe the defendant said he had the child in a car seat and might have bumped the car seat and caused some kind of prior injury. And so there was supplemental information with regard to what prior injuries might have occurred, but they simply weren't credible. And it appears to me that at the end of that motion in limine, and if you go through and read the transcript of the motion in limine, there are three items really up for grabs. One was the autopsy, one was the statements of the defendant, and the third was the admissibility of the polygraph testimony. The state very clearly said, we're not going to admit anything. We're not going to mention polygraph. We don't take issue with that. But the other issues with regard to the autopsy and the statements of the defendant seem to go towards credibility. The trial court is the one who frames the response to the defense. And when he does so, he says, I see this as 455 evidence. I see this as absence of mistake or accident. This is 6455. He says, however, that is balanced against the other use of this information, and that is one of credibility. And when you look at the statements that the defendant made with regard to the contact that he had with the child, and even categorizing them as a confession, I think that's still accurate. And it was a confession. It was a confession of the fact that he isolated the timeline that he was with that child. It was a confession to the fact that he had hands on this child. And it was a confession of the fact that he at least shook that child, and he demonstrated such on video.
Let me ask you a question. So do you agree with the trial court judge and also, Justice Stegall, is this evidence of a prior bad act or a prior crime?
In all honesty, when I reviewed this transcript, and I was not the trial attorney on this case, I reviewed this transcript. That the first boring question I had in my mind was, is this 6455? Is this a prior crime or a bad act? Now, certainly we don't use the title of a statute to define the content of a statute necessarily. When I look at this, I had trouble finding this to be a prior crime or bad act, kind of in the idea of propensity of violence.
Okay, let me ask you this. Could the dad have been charged for the prior shaking as child abuse because of the injuries to the ribs?
Could he have been charged? I would say, I'd probably give you the same answer I'd give with regard to any crime, Justice. And that is, if there's probable cause to believe he's committed all of the elements of that offense, and we have sufficient evidence to believe that he was actually the person that did that.
Mm-hmm.
But I think it is far more specious for me to say that we had enough evidence to charge him with that second event. I don't
No,
believe-
I want to focus on whether the trial court judge said it's 6455.
Right.
It's prior bad act or a prior crime.
Sure.
All I want to know is whether you think that's true, that the prior shaking softly with, in combination with the healing rib injuries, whether that would be a prior crime or prior bad act. In other words, was the district court correct in saying this?
I would
is
love to give you a black and white response
So
to this.
I would love to hear a black and white answer.
And I can't, and I'm sorry, I can't. Because I don't know the nature, I don't know the circumstances, and they're not fully developed, and nor do we get more of the story from Mr. Hogan of exactly what went down with the prior injuries.
Well, can we
What I
say
have is-
Isn't that the
committed a crime?
point?
I'm sorry?
Can we say someone committed a crime? And then that gets to this defense argument that the state inferred it was Mr. Hogan, but yet there's no evidence that it was Mr. Hogan.
I think the prior injuries, and I have to keep my mind broad every time I hear about child victim injuries, I would need to know more before I would say, yes, that's clearly criminal conduct.
Okay, so let's say that it is. Let's say it's a prior crime or bad act. Let's
Okay,
go with what the district court judge concluded. It doesn't seem as if anybody objected to his characterization that way. So then what happens is it can't come in unless but it can be used. It can't be used for propensity, but it can be used for motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or accident. And if it is one of those, then the court has an obligation to determine whether the probative value outweighs its prejudicial effect. And so let's say that we find it's probative, okay? Did the district court err in failing to say anything about the prejudicial effect? Well, actually, when you look at probative value, let's look at probative value. Here's what we're supposed to consider, and this is under the Clarehout decision from 2019 that we issued. So when he's just talking about probative, how clearly was the act proved? The prior bad act, okay? How probative is that evidence on what is being charged in this case? How seriously disputed the material fact is? And whether the government can obtain any less prejudicial effect, okay? You could say that the judge found probative value, but I don't see that any of these things were considered. But then you have to go to prejudicial effect, the likelihood that the evidence will contribute to an improperly based jury verdict, distract the jury from the central issues of the trial for this particular act, and how time consuming it would be to prove the prior act. But of course, they never proved the prior act, so it wasn't time consuming. But I just don't understand, did the district court err in doing all this? It just seems like there was absolutely no weighing of probative value versus prejudicial effect.
and if I'm to understand correctly, it's the statements that the defendant made that are inherently so prejudicial, or at least that's how you're couching that question or the point that you're making?
No, bringing in the prior bad act or prior crime of the previous shaking 6 weeks earlier, that they are asking the jury to infer that he committed that crime
Sure.
because of the old.
If I may just add some context here, that you may want to add into this, your answer to Justice Standridge. All I could find in the limine transcript, motion limine ruling, was the judge making this passing statement. And the court finds that the probative value of the 6-week-old injury evidence outweighs its prejudicial effect. And then he goes on to say, I will need to give a limiting instruction. If there's something more in the record that I missed, you might point that out to us as well as you talk to answer Justice Standridge's question.
Okay, trying to address both of you equally, but I'll address this first, if I may, which is I'm not aware of anything else in the transcript where there's an elaboration of the probative prejudicial balance with regard to this.
So those factors that Justice Standridge mentioned.
Right. So no, I'm not aware of any well-developed, I guess, like I said, transcript or the fact that colloquy might have occurred even beyond the transcripts. But I'm still struck between the idea of we have probative prejudicial, which is, we weigh that for every bit of evidence that we have, and use for trial to distract the jury. And that's, and that was one of the factors that was mentioned as well. But this wasn't, the case was not reliant upon the prior injury. This evidence was admitted, but again, how do you pair out?
I'm just talking about when, the judge made a decision here. The judge's decision is reviewed for abuse of discretion.
Sure.
One of the issues, one abuse of discretion is an error of law. Why isn't this an error of law that the judge didn't even consider the prejudicial effect, let alone, the elements of the probative value? But you could say, well, but he talked about the probative value enough that, he doesn't have to state, or she, I don't remember who the judge was, but state everything on here. But there's just no contemplation of all, which, I mean, it seems like that the prejudicial effect might be a pretty big issue.
I think undoubtedly, every time we look at 6455 evidence, we always worry about the prejudicial effect.
Well, this
This
judge
is why
didn't really,
455 is a statute.
Yeah.
This is why we have it codified. and this
did
is
the
why we have-
district court judge err? Did the district court judge abuse its discretion?
I think those factors need to be weighed. I think the fact that the transcript does not necessarily contain that balance of going through the probative versus prejudicial at length with regard to the factors.
At length?
There was no length. I mean, he just said, but I mean, absolutely. I can't change the transcript, but
Summary conclusion.
I think that was also, it was a summary conclusion, but the debate, the back and forth, I think if you look at the entirety of the transcript of that hearing, was considerably longer. The content of what it is that's being addressed here, the trial court gauged.
It all went to probative value. The whole transcript.
Sure, but the court's rationale was also focused upon the admissibility of this information under credibility issues, 6421, 422, those types of matters.
Well, let's just, what if, just for a second, pretend that the court infers that finding is made. Why isn't this prejudicial? What is the case for it not being prejudicial? Because I think it strikes me that the explanations for its admission, credibility, meaning that he didn't gently shake, he actually abused the child, and not a mistake, meaning that he did those prior things. It seems an argument might be made that propensity sort of permeates those rationales. But I want to hear your argument as to why that may not be the case. And
the first part of what you proposed was, isn't this actually prejudicial? And I would say absolutely. Everything the state presents
unduly
is prejudicial. So it's really the balancing test of probative versus prejudicial amongst, it also has to be relevant and et cetera. We know these things, but
I guess the
Well, it's
question is,
really
why doesn't the prejudice outweigh?
It's really the risk of undue prejudice. I mean, sure, what you're saying is
sure.
a lot of it's prejudicial, but here the weighing is, does the probative value outweigh the risk of unfair or undue prejudice?
My answer to you is it was accurate in this case to admit this evidence. And I go back to what I opened with, which was the statements of the prior injuries. The jury needs some explanation of the fact that we're looking at an autopsy of a dead infant that has prior injuries. Is nobody to address that?
And
Is that not to be explained to the jury? And so in doing so, we have to say, and the state played their cards. They said, this happened to this child. He's not charged with these crimes. We don't know whether Kaleb Hogan committed those injuries to the child 6 weeks before the death, or somebody else.
Right, and that's what I would like for you to focus on right now.
Okay.
If a judge's ruling can be right for the wrong reason. So if, for argument purposes, we assume 455 doesn't apply because you can't prove that the defendant did a prior crime or civil wrong that relates to that prior injury. So set aside 6455. You have an autopsy that has evidence of a prior injury and a current injury. That has to be sorted out somehow. What was caused recently? What was caused long ago? What is there an interrelated effect possibly? What is your strongest argument that the evidence of the old injury to the ribs, to the brain, was relevant and probative to the charges in this case?
Best argument I have is that
I'm sorry, material and probative. Those are both things that are subparts of relevance, and all relevance is presumed to come in. So what's your best argument? I'm sorry, I misspoke. That evidence of the old injury was both probative and material.
probative as to the defendant's credibility regarding the statements he made. He told law enforcement officers that interview with Captain Ralph that the prior injuries might be connected to he mentioned something about he was in a car seat, might have bumped the car seat, and he had some kind of contact that may be related to the prior injuries. It was a minimization on behalf of the defendant. Just like it was a minimization when he later described the shaking that he did with that child, and he minimized it. Now, in both circumstances, this is a question then of the credibility of the defendant and how that's weighed.
So evidence is probative if it has any tendency to prove a material fact where, a material fact is a disputed material fact.
Sure.
So was his credibility, what did he lie about?
I believe that he completely minimized the fact. He never said, I killed this child by this means and thoroughly went through it in great detail. He minimized it. His credibility, the defendant's credibility in those statements have to be tested, have to be aired out in front of the jury. And it's the jury that has to decide whether or not he is credible. Those statements, or the statements that he made, were credible. That's essential in this case as well as most others, actually. Was the defendant, any statements that the defendant made that are admissible have to be tested for credibility.
So doesn't that swallow the whole rule then? Because
sorry,
credibility, you can't use it for propensity evidence.
Sure.
But even though it's not listed in the statute, as Chief Justice Lukert mentioned, but if you're saying that everybody's credibility is always at issue, doesn't that swallow the rule of, well, propensity evidence can always come in?
No, I think that if it's going through the route of 6455 and is one of those 8 identified factors.
Which credibility is not one of.
Absolutely. But that's just it. If it's one of these factors, which again, the trial judge determined, he was the one that advanced the theory that this was 6455 in that motion in limine hearing. The state was looking at this going, this is mere credibility issue. We're going to admit the autopsy. We're going to have some explanation as to the prior injuries. And it was in response to the defense initiating
Well,
this.
it's so bad to not have the prior injuries in.
I'm sorry, why would it not be so bad?
Right. I mean, couldn't you prove the case without the prior injuries?
You could, but that would also require, like I said, a trial court to then start excising every autopsy to determine what is scientifically relevant to the death versus not. Can we talk about this? Can we not talk about that?
Or could there have been a limiting instruction that just said you can't weigh those prior injuries against Mr. Hogan?
Well,
If there's no evidence.
and that's where I think, if nothing else, the saving grace and and I don't mean to be, ever be flippant about our judicial system here. I have yet to be part of a perfect trial, no matter what it is. And I think that as the course of this case went through, Judge Ricky heard this evidence on this motion in limine. He anticipated, hey, you know, it's seemingly 6455 to him. And if we are going to do 6455, the law is going to require that limiting instruction. And he proposed at the end of that motion in limine hearing, I'm going to go ahead and prove that, make sure it's in the journal entry of today's hearing, that we will have a limiting instruction. And then certainly when it came to trial, there was a limiting instruction.
And it was not objected to.
Correct.
We're in clear error land. And one question I have about as we get to that area, do you consider the objection that was made, so that as I understand, the procedural history of this was that there was the motion in limine ruled on, then at trial, when the forensic pathologist was testifying, defense renewed their objection to the admission of the autopsy report. The judge ruled that the autopsy report and related testimony would be admitted, and defense counsel made a continuing objection. Do you understand that continuing objection to be to any evidence of the prior injury throughout the trial, not just to that witness? Or do we, when we get to harmlessness, consider the fact that it came in multiple times in the trial? And I mean, just what was the effect of the continuing objection?
I think I would be in the treacherous area of divining what those words meant from the transcript. I would say that I would just have to rely on the transcript of the trial. I think that, and that's all that was said, I believe, which is, I noted the continuing objection.
And I noticed the state didn't, or hasn't argued preservation of the, you know, so I take it, you take it, the continuing objection does apply to the trial.
I would anticipate it as such, and I think with regard to the reservation, to me, the context of that when I went through those transcripts were, this is what this is referring to, and we'll refer to someday when we're before a higher court.
Okay. Any other questions?
Just hopefully this is real quick, but it refers back to an earlier question Justice Standridge asked, which is about charging for the prior injuries. Presume the state's theory of this case was that the defendant had abused the child 6 weeks earlier, and then the incident that caused the death, right?
I'll stop you right there. No. What the state's theory was, he committed acts, I believe, on or about March 23rd, 2021, that led the acute injuries on that date led to the child's death.
Had you charged the defendant with the abuse that occurred 6 weeks earlier, all this evidence would have come in, right? There wouldn't have been any question about 64.
Absolutely.
So my question is, isn't one of the purposes of 6455 to essentially tell the state, look, you can bring this evidence in, but what we don't want you to do is allow a jury to consider essentially that it lowers your burden of proof. Like if you had charged him with it, then you have a high burden of proof. You could have got this evidence in by charging it. The concern in 6455, the policy concern, I think, is, look, we don't want a jury to consider unproven allegations as propensity evidence. And that's how I understand the defendant's primary argument. So I just wanted you to respond to that based on the purpose, the policy purpose of 6455.
Well, what you are discussing is the initial charging phase and how the initiation of a prosecution for the purpose of looking at what all evidence might be admissible in trial and ultimately potentially lead to a conviction. I don't agree with the premise that 455 is somehow directive of going, hey, prosecutors, make sure you charge everything at the get-go of this case. Add more crimes so that way it comes in and then you don't have to go through this gateway. I think 6455, first of all, was not anticipated nor filed, that we did not initiate this as a 6455 admissibility issue. This was something imposed upon us by the trial court. Defense opened the door to it. When you talk about the state's theory or how we should progress or how we should even charge this, not on our radar until that hearing that day, until the hearing on the motion in limine. And that's the first time it was discussed as 6455 because that was postulated as being exclusion or necessary to be excluded by defense counsel. So the court says this is 6455 and he couches it under the two rationales, one of credibility, the other under 6455 absence of mistake.
I understand all that. I guess my point is just, I'm questioning whether or not, and I think you said you don't agree with me, but 6455's purpose is to eliminate ghost charges. You can't have a ghost charge that you don't actually have a burden to prove.
No, I see.
If you disagree with that,
honestly,
that's fine.
I've never contemplated it in that fashion. I really haven't. And is that a directive of sorts? And I guess if so, it's either a subtle one or I'm a dullard and never caught on to that. But I believe this is about. I don't believe that our existing law under 455 is using this evidentiary rule as a directive, as a signal or a beacon to prosecutors of make sure you charge everything for admissibility. I think that's some five-dimensional chess going on if it is. And so again, maybe I'm just don't have the wisdom to have looked into it under that light, but I respectfully disagree that that's the assessment.
But it was always your intention to talk about the prior injuries with the jury, right?
It was always the state's intention to admit the autopsy in full.
Which would include the prior injuries, which would have, it's not like you were going to put this in and then not talk about, I mean, you just can't just let it lay there. Right?
That was the quandary we were in,
Well, I don't care about the conduit. Your intention was to put evidence of prior injury in front of the jury, right? That's what was going
Yes.
to happen with what you were going to do.
Yes, the autopsy. Yes.
Well, isn't it possible that that prior injury somehow is relevant to the seriousness of the current injury? That perhaps he was right, and the defendant was being truthful. I only shook him gently. And here we have evidence that something else happened to him before, and that may have contributed to what very little I did, or which would minimize his culpability.
It would, but the coroner and pathologist, they both testified and said that there were prior injuries, but it didn't capitalize on that. And there was some severability, I guess, with regard to those healing injuries. They said that there was evidence of old brain bleed and healing rib fractures. I believe at the time the child died, the child had 16 broken ribs, but noticed that 6 of those were healing. And
it could have benefited the defendant to say, look at all these other things that happened to this poor child, and we don't know who had access to him or who did those things during that time. But what I did not cause his death.
And I think that's what he did proffer. And I think that's what was put forward at trial. And he did advance that theory.
Is that relevance to the total evidence without even considering 455?
As to the credibility of his statement?
As to the overall cause and effect of what the doctors found when the child was on the table, deceased.
Relevant to explain the evidence to the jury so they could make a reasonable decision. Yes. It is relevant to the res gestae, the body of this case. Say you have a child who's 3 months old, has 6-week-old injuries that are healing, has present acute injuries that led to the child's death. You have the only people that say that they had any type of physical contact that would have led to injury is the defendant, Kaleb Hogan. He's given statements about the past injuries, but the present injuries seem to be minimized. As a result, his credibility becomes extremely valuable when you look at that in total with the autopsy and the prior injuries and the knowledge that all of that needs to come out. Shedding light on what is the story was, shedding light on what the defendant had to say, and trying to explain to the jury even-handedly, and with the inclusion of a limiting instruction with regard to how to use that evidence, was the best protective that we had under the facts of this case.
So
Is
you
that
just,
relevant even if you assume he did not do the prior injuries?
I think defense could advance that theory that he did not do the prior injuries, but
But is the
I don't know that
relevance-
any of us know that.
Is the evidence of the prior injury relevant if you assume he did not do those prior injuries? Because 6455 only applies if he did.
Mhm.
So if you assume he didn't, what's your best argument that the prior injuries are still relevant in being material and probative?
If I assumed he didn't do it, then I think that the evidence would still have to come in to explain his statements and the fact that there are at least were some injuries and that he is at least among those that were suspected of committing that type of injury. But I don't know. I don't, and I don't. I have no idea who committed the injuries or how those injuries occurred from 6 weeks before. Be that the mother, be that the defendant, grandparents, anybody that had contact with that child. So I can't tell you today. I know Kaleb. I know that he committed the injuries from 6 weeks ago, and that's precisely why he's not charged with the crime of child abuse.
Do you need it to tell a full and complete story of the existence of the physicality of that child at the time of his death?
I don't even know if I heard exactly what your question was. Could you
Well,
repeat that?
do you need it to fully explain how the child was at the time of his death? Because you have to connect what the defendant did to the deceased's condition. So do you need it to fully explain the condition of the child at the time of his death? Or not?
I believe that the explanation is merited. This child was 3 months old when he died. That's a very short period of time, sustaining 6 broken ribs and then later 16 broken ribs in 3 months. In 12 weeks, this child was horrifically abused, and then you've got the the other injuries as well. I think in total, yes, I think that's going to be an explanation that a jury at least needs to weigh and look into. The jury needs to go, oh, what's going on with this child? Was this child, and I think they would ask the question, but it was explained at trial as well as, did the injuries that occurred 6 weeks before contribute to or accelerate any of the problems that occurred on March 23rd? And it seemed to me when I read through that transcripts seemed to indicate that they said, no, they weren't life-threatening 6 weeks ago, but certainly there's still evidence that they're healing injuries. But you're talking about a very short period of time that this child was between birth and death. We're talking about a very narrow window of time here. And to be able to explain that to a jury and say, this is what this child's life looked like in those 3 months, I think is absolutely appropriate. And one of the cautions, I guess, that seemed evident with this from the very moment that the trial judge made the order was But we are going to give a limiting instruction. We're going to make sure that the jury understands that you can't use this prior injury, that needs to be separated out, and the charges for which the defendant is standing trial is for the acute injuries here. But
Is there any evidence that an already injured child is easier to injure?
well, I think that's certainly, I think that is possible, but not. in this
Aside from
case.
what you think, is there anything in the transcript, respectfully, is there anything in the transcript to indicate that?
No, I don't believe so.
Are there other questions? Okay, thank you, sir.
Okay, thank you very much.
Ms. Davis?
Just briefly, I think what your questions today show is what my brief tried to point out to you, is that the state had the burden to establish the admissibility. And at that motion hearing, the prosecutor was didn't present. And the judge had an obligation as a gatekeeper to hold the state to that burden and to make the state proffer the evidence. And the judge didn't do that.
On that
The
point.
state didn't proffer anything, so the judge just made his own assumptions.
So on that point, am I correct in looking at the record that there was never any discussion of the res gestae exception to 6455 evidence?
No, there wasn't, and I thought Gumby had done away with Ray Gestae, that everything has to come in through 6455.
Okay.
So
Yeah, we
Basically-
declared race gestae dead in Gumby. I think,
Yeah.
I think that was almost the words, but
But is it dead?
we have revived it.
Okay.
I mean, it's been revived. And that's kind of my question. I was waiting for you to get up here. Why isn't it as a part of our extension after Gumby, this come in under race gestae? What's your answer to that?
because the state didn't establish that.
Well, that was
And-
going to be my question.
I
Is
mean,
it-
we
is-
can't-
Are we unable to consider it because it wasn't considered below? And just for reference, in our Sieg decision from 2022,
Right.
we clearly say that, acts committed before, during, or after the happening of the principal occurrence, which are so closely connected,
Uh-huh.
form a part of the occurrence, are not subject to 60.
Since we're supposed to object at trial in order to raise issues before this court, you think maybe the state could raise
Yeah, well, that was my question.
issues before the trial?
I presume your answer is yes, we are prohibited from considering race justice.
They needed to come forward and say, this is why we want to. And you know what? There was an omission here, because when the judge said, I'm going to admit these evidence because that states, I'm going to admit this evidence. It wasn't just the autopsy report. In the interviews with the detective, he was repeatedly telling the parents, they're seeing prior injuries on this child. The prior injuries were all over everything, right? They were in all the interviews because the hospital identified him that night. Now I lost my train of thought. At the hearing, the motions hearing, when the judge says that, the state's going to present evidence of a causal link between the defendant and the prior injuries. The prosecutor needed to jump up and say, no, we don't have that evidence, Judge. The state wanted this prior injury evidence to come in to show propensity. They were just trying to sneak it on in there, right? The prosecutor never stood up and said, we don't have that evidence, but we want to admit it to give the jury a full picture of this child's condition. And you know what? We have an expert that can say that the prior injuries contributed to the death. The prosecutor didn't say that because they didn't have an expert, because they didn't proffer that evidence. The defense expert said that the prior injuries did not contribute to the death. So really, this is a failure of the state to prove that this evidence is admissible, a failure of the judge to hold the state to its burden to do that, the failure of the judge to act as a gatekeeper. And I did note on the, you don't even need to admit the autopsy report. He's not contesting that the child died and these were the injuries. I mean, the only reason to get the autopsy report in is to argue propensity. He's not contesting this. And then it was a car seat. It's not a car seat, it's a carrier. The mom wore all day, had the baby in a carrier when the bruise developed. That was what they were talking about. And then just to really clearly, I know I'm out of time, but on the prejudice, it's that the likelihood the evidence will contribute to an improperly based verdict. That's the unduly prejudice. Improperly based. It's an emotion. Emotion and reason are two different horses going in different directions. I think that's Plato. You can't reason and emotion. That's the problem with this evidence. Anyway, I'm out of time.
Any other questions? Okay, thank you.
Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement.